In this video, we're going to talk about how emergency custody works in Indiana. About me, my name's Nathan Vining. I'm a family law attorney here in Indiana, and I help people with emergency custody situations regularly and can help walk you through what you can do if you're facing an emergency in your custody case. And can talk about what you can do if you're facing an emergency that involves your child and you need to do some emergency custody action quick. So what is emergency custody? It's a legal process where you can go and file for emergency custody in order to attempt to protect your child. It's a lot of times something where the court will hold a hearing within the first 30 days. It won't be the longest hearing necessarily, but it'll be a quick hearing where the judge can hear evidence as to why something needs to happen with regards to your child. Some common situations would be you have concerns about parenting time and you think the parenting time needs modified on an emergency basis, or there can be things with your child themselves, such as maybe they need some kind of treatment that the parents don't agree on and you need to file an emergency so the child can get a certain kind of treatment. That's what an emergency custody modification would entail. A lot of times it's situations that involve some kind of immediate risk of harm to the child's emotional or physical well-being. So that's emergency custody. And when you should file, there's a lot of different times. Sometimes DCS may be involved. You can file emergency custody to try and get ahead of the situation and address this with your family court judge. There's also times where the parent's unable to provide care. Maybe there was somebody in an accident and you need to file emergency custody, so there's a custodian for the child in the interim. Or there's even sometimes where the child themselves is having behavior issues and you need the court to be involved so you can help address these issues. Examples of when to file for emergency custody. Sometimes I've seen this kind of case a lot where the parent takes off with the child and moves out of state or to another location. You could file an emergency custody and ask for a return of the child. Another is if the child's involved to some kind of substance abuse or domestic violence in the home. Other times there can be abuse allegations involving the child. You want to file emergency custody. Or there's times where there's like some issues with the housing or living conditions where the child's constantly being late to school and it's impacting them. Or even just the child's own mental health is they're struggling and they need some help and you need to change custody in order to help get the child the help they need. So those are some examples of when you would file for emergency custody. The standard for emergency custody in Indiana, it's the same as all custody cases. The court would look to the best interest of the child. I have several videos over what the standard means and what you can do to make a best interest argument in your case. And then if the court is going to restrict parenting time, what they would be looking for is if there is some endangerment to the child's emotional or physical well-being. And at that point, they would restrict parenting time, even up to potentially supervised parenting time if necessary to protect the child. So the standard for modification, again, 2.2, and it's really when the modification would serve the best interest of the child. And the steps to file for emergency custody. Essentially, you should definitely consult with an attorney. If it's an emergency, it's something you don't want to mess around with and try and do things on your own. Then you would file that emergency motion, provide the court with some allegations as to why it's an emergency and why you should have that quick hearing. And then from there, gather your evidence. And the court typically holds a hearing. A lot of times it's a 1, maybe 2-hour hearing, sometimes even as quick as a 10-minute hearing, so the judge can understand what's needed and then take actions from there. So that's the steps to file. And then there's a lot of different evidence you can use to support it. You should get any DCS records, police records, school records, or medical records that are relevant, and then any witnesses that you believe you need. And again, these are quick hearings, so it's really essential to be prepared. So if you have 30 minutes of an hour hearing, you can go and hit the right points quickly. A lot of times I have clients that don't feel comfortable in these because you don't get to necessarily take the time you would in a normal custody trial. They're very quick and you got to hit the right points quickly so you can let the judge know what's going on in your situation. And then from there, they typically require you to go to mediation or hold a longer hearing sometime in the near future. And that's where you can go into a lot more detail. But these emergency hearings are quick. You don't necessarily get to go into all the details of your family that would make you feel comfortable. That's why you have to hire an attorney, because we can go through and help understand what the judge needs to know in that quick time period and help them get the right information so they can make decisions and help protect your family. Again, what to expect, a hearing within 30 days. The court typically, if you satisfy your burden, would take measures to ensure child safety, and then they will typically set some other future court dates or mediation to go into things further. And then another big thing is sometimes you can ask for review hearings. So ask for a review hearing in 30, 60, 90 days. That way the court can keep apprised as to the developing situation. If there's an emergency involving your child, you don't want to go it alone. You want to get advice and know what to do and how to protect your child and your interests. So that's the best thing to do. So if you're dealing with a situation, what we outlined here, give me a call. You can call or text and we can set something up. I'd be happy to talk, review your situation. We work throughout the state and can help you today.